A Supreme Court ruling just dropped, 9 justices, 0 dissent, and it directly affects every single person who has ever carried a firearm in their vehicle. I'm not talking about a minor technicality buried in a footnote somewhere. I'm talking about a ruling that fundamentally redefines what police can and cannot do the next time they pull you over and find out you're carrying. If you own a gun, if you drive a car, and if you think you already know your rights, stop what you're doing right now. Because what the Supreme Court just decided is going to shock you. And more importantly, not knowing about it could cost you your freedom. Before we get into it, do one quick thing right now. Hit that subscribe button. Here's why it actually matters this time. The ruling I'm about to break down happened recently, and most gun owners still have no idea it exists. 90% of the people who needed this information most are going to find out about it the wrong way, sitting in the back of a police cruiser wondering what just happened. I don't want that to be you. And later in this video, I'm going to give you the exact 5 words, recommended by defense attorneys, that you should say if an officer ever asks to search your vehicle. 5 words that could be the difference between walking away free and facing charges you never saw coming. So stay with me, because we are just getting started. Let's set the scene. You're driving home. Legal firearm in your center console. Permit in your wallet. Following every rule in the book. You get pulled over for a broken tail light. Routine stop. The officer approaches, asks if there are any weapons in the vehicle. You do the right thing. You're honest, calm, and cooperative. You tell him about the firearm and exactly where it's located, and that's where everything goes wrong. The officer, citing what he calls officer safety concerns, decides that the presence of a firearm in the vehicle is enough justification to conduct a full search, not a quick glance around the seat. A full, thorough, top-to-bottom search of the entire vehicle. No warrant, no probable cause beyond the gun itself, no evidence of any other crime. During that search, the officer finds a small amount of ammunition that technically violates an obscure local ordinance. An ordinance, by the way, that the driver had never heard of and had no reason to know existed. The driver is arrested. Now here's the part that made this case explode. When the driver challenged that search in court, the lower courts sided with the police. The judges ruled that when an officer knows there is a firearm in a vehicle, even a legal one with a valid permit, that knowledge alone is sufficient to justify a warrantless search under what's called the automobile exception to the Fourth Amendment. Read that again. Legal gun, legal permit. Honest disclosure. And the court said that was enough for police to tear your car apart without a warrant. Think about what that actually means. If the mere presence of a legal firearm, something the Constitution says you have the right to own, is enough to bypass the Fourth Amendment, then your rights aren't rights at all. They're suggestions. Suggestions that can be ignored the moment a police officer feels uncomfortable. That ruling sent shockwaves through the legal community, because what it essentially said was devastating. It meant that exercising your Second Amendment right to carry a firearm would automatically cancel out your Fourth Amendment right to be free from unreasonable searches. You couldn't have both. Pick one, carry your gun or keep your privacy, but not both at the same time. That is the question the Supreme Court agreed to answer, and the answer they gave was historic. 9-0. Let that sink in for a moment. In a court that is deeply divided on almost everything, in a country that can barely agree on what to have for dinner, 9 justices looked at this question, and every single one of them came to the same conclusion. The Supreme Court ruled that legal firearm ownership in a vehicle does not, by itself, constitute probable cause for a warrantless search. Period. Full stop. No exceptions carved out for specific states, specific situations, or specific types of firearms. Legal gun ownership is not evidence of a crime. It cannot be treated as suspicious activity. And it absolutely cannot be used as a standalone justification for violating your Fourth Amendment rights. The court was direct in its language. The justices said that treating the lawful exercise of a constitutional right as grounds for suspicion fundamentally undermines the structure of the entire Bill of Rights. You cannot punish someone, and make no mistake, an unjustified search is a form of punishment for doing something the Constitution explicitly protects. Think about what that means practically. The Second Amendment gives you the right to own and carry firearms. The Fourth Amendment gives you the right to be free from unreasonable searches and seizures. The Supreme Court just said those two rights are not in competition with each other. They coexist, both deserve equal protection, and no law enforcement officer gets to decide that one cancels out the other. In today's climate, when the Supreme Court is usually split 6-3 on nearly everything, a 9-0 decision sends a message that is impossible to ignore. When you see that kind of unanimous vote, it means the legal principle is so fundamental, so clear, that there is simply no room for reasonable debate. It sends a direct message to every police chief, every prosecutor, and every lower court judge in the country. Stop using the Second Amendment as a backdoor to violate the Fourth. Now, I want to be clear about something before we go any deeper. What I'm giving you here is educational information to help you understand this ruling and what it means for your rights. This is not legal advice for your specific situation. Every case has unique facts. Every state has different laws. And if you're ever facing a real legal issue, you need a real attorney. What you can take away from this is knowledge. And as you're about to see, knowledge is enormously powerful. To fully understand why this ruling is such an earthquake, you need to understand the legal doctrine it directly challenged. It's called the automobile exception. This is a legal concept that has been around for over a century, and for a long time it functioned as basically a blank check for law enforcement. Normally, the Fourth Amendment is your shield. It says the government needs a warrant to search your belongings. But back in the 1920s, during Prohibition, the Supreme Court created an exception. They said that because cars are mobile, meaning you could drive away and destroy evidence before an officer could obtain a warrant, police could search a vehicle without one if they had probable cause to believe it contained evidence of a crime. For decades, that exception made reasonable sense. But lower courts and overzealous prosecutors stretched it until it snapped. They started arguing that if an officer sees a gun, or if you voluntarily tell an officer you have a gun, that safety concern automatically creates probable cause to search the entire vehicle. They were essentially treating your legally owned firearm the same way they would treat the smell of illegal drugs or a bag of white powder sitting on your dashboard. But here's the fundamental problem with that logic. Cocaine is illegal. A firearm owned by a law-abiding citizen with a valid permit is a constitutionally protected tool. One is evidence of a crime by its very existence. The other is evidence of nothing except that you're exercising a right the Constitution guarantees you. The Supreme Court looked at that lower court logic and said, enough. They clarified that the automobile exception still exists, but it requires actual articulable evidence of criminal activity. A legal gun is not evidence of a crime any more than a legal pocket knife or a baseball bat sitting in your back seat is. By ruling 9-0, the court stripped away the "he had a gun, so I searched him" excuse that has put thousands of law-abiding Americans into legal jeopardy. But here's the part of this ruling that is flying completely under the radar, and I need you to pay close attention because most people covering this story are missing it entirely. The Supreme Court didn't just rule on whether a gun equals probable cause. They also addressed what legal scholars call the chilling effect on constitutional rights. A chilling effect is when people stop exercising a legal right because they're afraid of the consequences, and the court addressed this explicitly. When law-abiding citizens are afraid to carry their legal firearms in their vehicles because doing so might invite a warrantless search, that is a chilling effect on Second Amendment rights. And the government cannot create that chilling effect through its law enforcement practices. This is massive. What the court is saying is not just that this specific search was wrong. They are saying that a pattern of treating legal gun ownership as suspicious creates a systemic constitutional problem. It discourages people from exercising their rights, and that is unacceptable in a country built on those rights. The court's reasoning also eviscerates a few other common tactics that officers have used for years to justify expanded searches. One of them is the high crime area argument. Officers will sometimes claim that because you're driving through a neighborhood labeled as high crime and you have a firearm, the situation is inherently dangerous enough to justify further action. This ruling is a direct hit to that reasoning. Your rights do not change based on your GPS coordinates. You don't have fewer Fourth Amendment protections in one neighborhood than you do in another. If the gun is legal, it's legal everywhere you legally have the right to be with it. Now here is the part that is going to sting for some of you, because I'm going to tell you the full truth, even when it's uncomfortable. This ruling is powerful, but it is not a force field. There are still circumstances where a search can be legally justified even after this decision, and you need to know what those are. If you are a prohibited person, meaning you have a felony conviction, a domestic violence record, or any other disqualifying factor that makes firearm possession illegal for you, this ruling does not help you. If an officer has reason to believe you shouldn't legally possess a gun, that's real probable cause and the search would likely be valid. If there are other factors present beyond the firearm itself, drug paraphernalia in plain view, the smell of alcohol, erratic behavior, outstanding warrants, or fresh signs of another crime, the officer can point to those additional factors to build probable cause. In that situation, the gun becomes one piece of a larger puzzle, not the sole justification for the search. If you are crossing state lines, this is an entire conversation on its own. What's legal to carry in your home state may not be legal in the state you just drove into. Reciprocity agreements are complicated and they change constantly. Crossing the wrong state line with a firearm can create serious legal exposure that no Supreme Court ruling will automatically fix. And if your firearm is being stored in a way that violates a specific state law, loaded in a state that requires it to be unloaded and encased, or accessible in a state that requires it to be secured, the circumstances change significantly. Know your jurisdiction. Know the laws of every state you intend to drive through. Now let's talk about something critically important that most gun owners completely get wrong during a traffic stop. And this is the part where I give you those 5 words I promised you at the beginning. Here's the uncomfortable truth. Even with this 9-0 ruling on your side, police have a secret weapon that can completely neutralize it. And that weapon is your own cooperation. Statistics consistently show that the vast majority of vehicle searches are not done because officers have actual probable cause. They are done because the driver gave permission. An officer will approach your window and say something like, "You don't mind if I just take a quick look around since there's a weapon present, right? Just for safety." And most people, wanting to seem cooperative, wanting to seem like they have nothing to hide, say, "Sure, go ahead. Do not do this." When you say yes to a search, you are voluntarily surrendering every protection this ruling just gave you. You are throwing your Fourth Amendment rights directly in the trash. The Supreme Court gave you a shield, but you have to be the one to actually hold it up. So here are the 5 words. If an officer ever asks to search your vehicle, your response is, "I do not consent to searches." That's it. 5 words. No lengthy explanation, no argument, no hostility, just a calm, clear, legally precise statement. Those words are legally powerful because they shut down the consent loophole completely. They force the officer to rely solely on probable cause. And as we just established from this 9-0 ruling, a legal firearm is not probable cause. Here is the critical nuance you must understand. Officers are trained to phrase search requests in a way that sounds like a command or like a natural next step in the conversation. "I'm going to need to check the rest of the vehicle for safety." You don't mind, right? If you say okay or "I guess so," or even just nod, you have just waived your rights. By saying, "I do not consent to searches," you are drawing a clear legal line that your attorney can use to protect you later. And if the officer says they're going to search anyway, do not physically resist under any circumstances. Comply with the physical instructions you're given, but make your non-consent verbal and unmistakably clear. Say it out loud, more than once if necessary. "I am not resisting, but I do not consent to this search." That statement creates a legal record that your attorney can use to challenge everything that follows. Think of it like the vampire rule. A vampire, according to legend, cannot enter your home unless you invite it in. A search works the same way. It cannot legally enter your vehicle, the space the courts have recognized as an extension of your personal privacy, unless you open the door yourself. Don't open the door. Now let's make the entire traffic stop as practical as possible. Because the most dangerous part of this entire topic isn't the courtroom, it's the 10 minutes you spend on the side of the road with an officer. You can be 100% right on the law and still end up in the back of a squad car if you don't handle the interaction correctly. Knowledge without execution is worthless, so here's exactly how you handle it. The moment you see the lights behind you, pull over safely and promptly. Turn on your interior dome light if it's dark outside. Put both hands on the steering wheel at 10 and 2 and keep them clearly visible. This is not about submission, it is about removing any ambiguity that could escalate a routine stop into something dangerous. You are immediately signaling that you are calm, in control, and not a threat. When the officer approaches the window, keep your demeanor steady. If your state has a duty to inform law, meaning you are legally required to disclose that you are carrying, do it clearly and calmly before reaching for anything. Say it like this. "Officer, for your safety and mine, I want to let you know I am a concealed carry permit holder and I have a firearm located in the center console," or wherever it actually is. Disclose the location before you reach for anything so there are 0 surprises. If your state does not require disclosure, but you choose to volunteer it anyway, the same calm clarity applies. This ruling now means that honest disclosure of a legal firearm cannot be turned around and used against you as automatic justification for a search. The court made that explicit. If the officer asks you to step out of the vehicle, comply immediately. Under existing legal precedent, officers have the right to ask you to step out for their safety during a traffic stop. Do not argue that point. Do not resist. Stepping out of the car does not give them the right to search the car. It just means you're standing on the curb instead of sitting behind the wheel. If the officer moves toward searching the vehicle without your consent and without stating valid probable cause, calmly say your 5 words. "I do not consent to searches." If they proceed anyway, do not physically interfere. Keep repeating, clearly and calmly, "I am not resisting, but I do not consent to this search." Every repetition becomes part of the record. After the stop ends, whether it was completely routine or whether something went sideways, write down everything you can remember as soon as possible. the officer's name and badge number, the exact words exchanged, the stated justification for any search that occurred, the time, the location, what was found or not found. That documentation is the foundation of any legal challenge that follows. Your notes are your evidence, and if you believe your rights were violated, contact a qualified attorney immediately. Do not wait. Do not assume it will work itself out. With this Supreme Court ruling now on the books, a rights violation that might have been difficult to challenge 6 months ago may now have a very clear legal remedy. Evidence obtained through an unconstitutional search can potentially be suppressed, meaning it cannot be used against you in court. This ruling may have just significantly changed outcomes for cases already in the system. Before we get to the practical side of all this, I also want to address something that affects people who may already have cases in the system right now. If you or someone you know had their vehicle searched based solely on the presence of a legal firearm, and that search led to an arrest or charges, this ruling could have serious and immediate implications. Under the legal doctrine known as the exclusionary rule, evidence obtained through an unconstitutional search can potentially be suppressed. Suppressed means it cannot be used against you in court. And if the evidence gets thrown out, the charges built on that evidence often collapse along with it. This is not a guarantee, and outcomes depend heavily on the specific facts of each case. But if this scenario sounds familiar, you need to be on the phone with a qualified defense attorney today, not tomorrow. Because with this unanimous ruling now on the books, the legal landscape for challenging those searches has fundamentally changed. Cases that looked like long shots 6 months ago may now have a clear path to a very different outcome. Now let's talk about something that's happening right now behind the scenes that most news coverage is ignoring completely. Law enforcement agencies across the country are scrambling to update their training materials and use of force policies in response to this ruling. And that process is not happening overnight. For years, many departments trained officers under the assumption that a vehicle containing a firearm automatically represented an elevated threat level. Some departments had informal policies treating gun disclosure during a traffic stop as a trigger for expanded search authority. That training was built on the lower court rulings that the Supreme Court just overturned. What this means practically is that there is going to be a gap. A period of time, possibly months, where some officers on the street are still operating under outdated training while their departments work to bring policies into compliance. During that gap, you may encounter officers who genuinely believe they have broader search authority than this ruling allows, not necessarily because they are acting in bad faith, but because the institution they work for has not caught up yet. This is exactly why your individual knowledge matters so much right now. Knowing this ruling exists, knowing your 5-word response, knowing that you have unanimous Supreme Court precedent backing your position, that knowledge is your protection during that transition period. You cannot control what an officer was trained to believe, but you can control how you respond, what you say, and what legal record you create in the moment. It also helps to understand what the court was not doing with this ruling. This decision does not eliminate the automobile exception. It does not make you immune from searches. It does not mean officers cannot take reasonable safety precautions during a stop. Under existing precedent, if an officer has reasonable suspicion that you are armed and dangerous, not just armed, but armed and actively dangerous, they can conduct a limited pat-down of your outer clothing. The court was not touching that. What they shut down was the leap from, there is a legal gun in this car, to, therefore I have the right to search every inch of this car without a warrant. That leap is now constitutionally impermissible. What the court requires now is what lawyers call articulable facts. The officer needs to be able to point to specific, concrete observations beyond the mere presence of a legal firearm that suggest a crime is actually occurring. Open containers of alcohol visible in the vehicle, the smell of illegal drugs, a firearm being stored in a way that violates a specific state law, behavior consistent with intoxication or impairment. Those are articulable facts. There's a gun, and it made me uncomfortable, is not. Step back now and look at what this ruling means from the broadest possible perspective. The Supreme Court of the United States just issued a unanimous decision saying that the Second Amendment and the Fourth Amendment are not in conflict, that both rights exist fully and simultaneously, that exercising one does not diminish or eliminate the other, that you are, in the eyes of the highest court in the land, a whole citizen with the full protection of the Constitution, not a citizen who has to pick and choose which rights they get to exercise on any given day. In a legal landscape that has been complicated, contested, and frequently hostile to gun owners, that is a genuinely significant statement. The fact that it was unanimous, that even the justices, who tend to be skeptical of expansive gun rights interpretations, agreed on this, tells you something important about how clear and fundamental the constitutional principle really is. There was no room for reasonable disagreement. 9 justices looked at the same question and reached the same answer. This ruling is going to be cited in courtrooms for decades. It will shape law enforcement training. It will be referenced in legislative debates. It establishes a principle that stretches far beyond traffic stops and vehicle searches. It stands for the proposition that in America your rights do not cancel each other out. The government does not get to construct a system where exercising one constitutional protection automatically strips away another. That is worth understanding deeply, not just as a gun owner, as an American. So let's bring all of this home. Here is everything you need to carry with you after watching this. The Supreme Court ruled 9-0 that a legal firearm in your vehicle does not automatically give police the right to conduct a warrantless search. Legal gun ownership is not probable cause. It is not suspicious activity. It is not evidence of a crime. It is the exercise of a constitutional right, and it will be treated as exactly that. You still have full Fourth Amendment protections when you are exercising your Second Amendment rights. Both exist simultaneously. Neither cancels the other. That is now settled law from the highest court in the country. This ruling does not make you untouchable. Prohibited persons, situations involving illegal carry, and additional concrete evidence of criminal activity can still justify a search. Know your state laws. Carry your documentation. Understand the reciprocity rules if you travel across state lines. Your behavior during a traffic stop matters more than you think. Be calm, be cooperative, be crystal clear about not consenting to searches. Save your legal arguments for a courtroom with a qualified attorney, not a roadside conversation with an officer who may not yet be aware of this ruling. Remember your 5 words. If any officer ever asks to search your vehicle and you do not consent, your response is, "I do not consent to searches." Calm, clear, legally precise. No explanation needed, no argument necessary. Just those 5 words delivered without hesitation. Document everything if a stop goes wrong. Names, badge numbers, exact words spoken, the justification given for any search, the time, the location, what was or wasn't found. Your notes become evidence, your evidence becomes your defense, and finally, stay informed. Because this ruling is significant, but the legal landscape around gun rights and police authority keeps moving, laws change, court interpretations shift, state reciprocity agreements get updated. The next ruling, the next legislative change, the next state law update could be just as important as this one. And the only way to stay ahead of all of it is to stay connected to information that actually matters. The Supreme Court just gave every law-abiding gun owner in America a powerful legal shield. Now you know it exists. Now you know how to use it. Don't let that knowledge sit unused. The next time you're behind the wheel with your legally carried firearm, you will be the most informed person at that traffic stop. Stay safe. Stay informed and stay legal out there, because in a country built on constitutional rights, the most powerful thing you can do is actually know what those rights are and have the knowledge, the confidence, and the preparation to exercise every single one of them, every single time, in every situation. That is what separates the people who stay free from the people who learn these lessons the hard way, sitting in the back of a police cruiser, wishing they had watched this video sooner. You now know the difference. You now have the information. Go use it and make sure the people around you have it too.